This hearing will come to order. While I'm disappointed we can't all be together in person today, I'm grateful to Chairman Graham and Ranking Member Feinstein and our clerk, Jason Covey, for facilitating today's hearing through WebEx. As an initial matter, I want to make clear that this subcommittee hearing is in no way distracting from the full committee and my personal work on other pressing issues facing our nation. Congress must address issues of police brutality and the horrific circumstances that led to the murder of George Floyd and the senseless deaths of so many of our African American brothers and sisters. That's why I'm grateful to Chairman Graham. And Ranking Member Feinstein for agreeing to hold a full committee hearing on policing in America, and I fully support that effort. We also have to continue to address the COVID-19 crisis and the impact it's had on millions of American lives and livelihoods. Just this morning, the full committee held a hearing on COVID-19 and its impact on federal detention centers. I'm also glad Leader McConnell and Senate Republicans are going to take up fixes to the Paycheck Protection Program. Work can and will continue to address this crisis. But while all of the other work is going on, it's crucial that Congress continue its important work, and I'm glad we have technology that helps us do that. When we started this review in February, we had no idea of the economic challenges that would soon grip our nation. The creative industry has shouldered outsized losses as our country deals with the coronavirus pandemic. Small creators, independent artists, authors, and musicians have suffered terribly during this pandemic. Live venues have been shuttered. Some may never reopen. Retail sales have plummeted, and yet the piracy of creative works online has not slowed down. Now more than ever, these small creators are dependent on the internet ecosystem, and strong efforts to combat piracy to sustain their livelihoods must move forward. Moving forward, we must consider how best to prevent piracy and ensure these small business owners get adequate compensation for their creative work. For those men and women, those creative individuals who are being absolutely decimated by the twin hammers of COVID-19 and an antiquated copyright law that lets piracy run rampant. With that said, today is our third official hearing in the subcommittee's year-long review of the Digital Millennium Copyright Act, or DMCA. Our first two hearings were more academic and focused on why the DMCA was originally enacted and on how our foreign counterparts handle the online pirating of copyrighted material. Today, we're going to talk about a more practical and potentially more divisive aspect of the DMCA. Section 512's notice and takedown provisions. When the DMCA was originally enacted, Section 512 was viewed as a grand compromise between copyright owners and emerging online service providers. In exchange for receiving a limitation on liability for infringing activities of their users, online platforms were supposed to follow certain criteria to curb online piracy, including making reasonable efforts to remove pirated material once they received notice that it was online. Unfortunately, as the Copyright Office recently noted in its report on Section 512, that grand bargain is no longer working, and the notice and takedown system isn't achieving the policy goals that Congress originally intended. Technology has continued to advance. Piracy has become easier and faster and much, much more common. Every year, copyright owners have to send hundreds of millions of takedown notices only to see infringing pirated material reappear on the same website, sometime just minutes later. At the same time, internet service providers, tech companies of all sizes, and members of the general public have to spend countless hours of manpower replying to takedown notices, instead of having that time to develop new and innovative products and services. So clearly, from both the content creator and content user perspective, the current system is failing, and it's failing badly, in my opinion. The Copyright Office's report is very informative about the problems in the current system and what could be done to rebalance and correct the current framework. But I don't think fixing the current framework is enough. I think we may be at a point where we need to design an entirely new system to combat online piracy. one that recaptures the balance that Congress intended and modernizes the copyright internet ecosystem for the 21st century. That's why last Friday, Senator Leahy and I sent a letter to the Copyright Office that asked them how they would design an anti-piracy takedown system if they had to start from scratch. I want to thank Senator Leahy for leading with me on this effort and for his interest in DMCA reform. He's been a leader on this issue since before I was even in politics, and I'm grateful to him and his team for their engagement during this year-long review. While we wait for the Copyright Office's reply, at today's hearing, I'm hoping our excellent panel of witnesses will provide us with insight about how the current notice and takedown system regime works or doesn't for them. One of the things I've learned early on in this process is that the DMCA reform bill is going to have to account for issues of scale. As Professor Rebecca Tushnet noted at our first hearing, if we design DMCA reform around addressing issues with large-scale market participants, all we're going to do is ensure that those individuals and companies have continued their market dominance. That's why today's hearing is going to hear from both content creators and users who operate at scale and those who don't. I want to understand the differences among the types of creators and tech companies whose actions are guided by Section 512 and how this affects our ability to send and to respond to takedown requests. I think understanding this difference will be helpful as we draft the DMCA reform measures and hopefully find a way forward that reflects and acknowledges the very real issues of scale faced by many in the internet ecosystem. I'm excited about today's hearing and our witnesses. It should be a fascinating discussion. And Senator Coons, thank you for allowing me to actually deliver the longest opening statement I've ever made, but I think it speaks to just how serious I think this topic should be taken. Senator Coons, Ranking Member.
Thank you, Chairman Tillis. As you noted in your opening, we are convening this hearing at a moment when our nation is riven by deep anger over the murder of George Floyd, by nationwide protests demanding action of Congress and our leaders at all levels on the long-standing grievances that relate to incarceration, to criminal justice, to policing, and to racial inequalities in our country. And I appreciate your opening comments, Mr. Chairman, that recognize that that is critical and urgent work we need to get to as a Senate and as a country. We also had a constructive full committee hearing this morning to talk about conditions in detention and incarceration and how the pandemic is impacting that. I agree with you that even in these challenging times, we need to also find a way to continue to work together on issues that are not as perhaps visible to the whole country, but that play a critical role in whether or not we will continue to be a vibrant and a creative economy and society. So let me just thank you for convening this hearing and for our witnesses who will be testifying remotely. I also want to acknowledge the tremendous work of the Copyright Office, which published a thorough report on Section 512 after years of study, multiple roundtables, and more than 90,000 public comments that were considered. I was struck by the report's conclusion that Congress's original intended balance has been tilted askew, that's a quote, and that takedown notices have not remedied the widespread problem of digital piracy. So I'll be brief. Mr. Chairman, I look forward to a productive discussion about whether we need to rebalance the DMCA to reflect the realities of today's internet. I know that we have a wide range of constructive witnesses on that heady topic, and I look forward to today's conversation and to our witnesses' testimony. Thank you.
Thank you, Senator Coons. I'll now introduce our panelists, our witnesses for the first panel. Mr. Don Henley is an American musician, singer, songwriter, record producer, and the former drummer and co-lead vocalist for the Eagles. He's given lead vocals on such hits as Witchy Woman, Desperado, Hotel California. I told Mr. Henley earlier today when I spoke with him that, in fact, the Eagles was the first live performance that I saw back when I lived in Nashville, Tennessee. And who knew at the time that he and I would come together in a Senate chamber to try and do what we could for the creators. Mr. Henley's also spent years advocating on behalf of recording artists and music-related issues. Mr. Henley, it's our honor to have you before us. Mr. John Berroya is interim president and CEO of the Internet Association, where he is also General Counsel. He leads legal, public policy, and regulatory initiatives for the association, whose members include Amazon, Facebook, Google, Microsoft, and Twitter. Mr. Douglas Preston is a journalist and author who has published over 30 books, both fiction and nonfiction. Mr. Preston has taught nonfiction writing at Preston University and contributed science articles to The New Yorker and other magazines. In 2019, he was elected president of the Authors Guild, America's oldest and largest professional organization for writers. Mr. David Hansen is an associate university librarian and lead copyright information policy officer at Duke University. He is responsible for Duke University Library's general research services and collections. His library division supports Duke researchers, including the development of the library collections and the support of creating and disseminating research and evaluating its real-world impacts. Thank you all for joining. We'll start, we'll go through the order of witnesses in terms of opening statements and in the order that I introduced. So, Mr. Henley, it's our honor to have you before the committee, and you may present your opening statement.
Thank you. Chairman Tillis, Senator Coons, and members of the subcommittee, I thank you for inviting me to participate in today's hearing. My name is Don Henley. I come here today with a heavy heart, mindful of the chaos and pain that has engulfed this nation. I'm aware that many in my industry have chosen this date to observe a day of inactivity and quiet contemplation. In being present here, I mean no disrespect to those who have chosen to set aside this day. I wish to state for the record that I stand in solidarity with my brothers and sisters in the creative community and with all my fellow citizens who seek a better and more just world for everyone. As a 55-year veteran of the music industry, I was asked by the chairman of this Senate subcommittee to come here and testify today on behalf of the creative community, songwriters, musicians, music publishers, all of whom are unfortunately known today as content providers. I am present today not to be contrary, not to advance a personal agenda. At age 73 and indefinitely homebound by the COVID-19 pandemic, I'm in the final chapter of my career. But I come here out of a sense of duty and obligation to those artists and those creators who paved the road for me and my contemporaries, and for those who will travel this road after us. It is truly unfortunate and patently unfair that the music industry is perceived only in terms of its most successful and wealthy celebrities, when in fact there are millions of people working in the industry, struggling in relative obscurity, people whose voices would never be heard were it not for hearings such as the one being held today. So I am compelled to seize this opportunity to discuss aspects of the fundamental issues that are foremost in the national conversation at this anxious moment. Those issues are fairness, digital gatekeepers. I have been targeted by the digital gatekeepers and their many shills and surrogates. It began last Friday in a newspaper that belongs to Mr. Bezos, a newspaper that is behind a paywall, and it continues today. Big Tech was probably hoping that this hearing would be canceled or that I would be intimidated to the extent that I would not testify. But I will not be silent on this issue. I want to do everything in my power to strengthen the property rights of music creators of all ages, all races and creeds, all styles of music, from hip hop to honky tonk, from rock to rap, to rhythm and blues, from jazz to folk to heavy metal. I want to change or improve outdated laws and regulations that have been abused for over 20 years by big tech, the enormous digital platforms that facilitate millions of copyright infringements monthly. So let me answer the question at hand. The notice and takedown system of the DMCA does not work for artists and songwriters. When a simple online search for a song returns an endless list of sites that never asked the copyright owner for permission, never received a license, and never passed on a penny to the artist for the use of their music, the system is not working. Today, when the marketplace has matured, the digital platforms continue to use Section 512 as a negotiating leverage to pay license fees which are well below market. The system is not working. When the burden of policing copyright infringements on global platforms lies with the artist instead of the massive technology companies who own and operate the platforms, the system is not working. The system is antiquated and badly broken, and the creative community is paying a very steep price. I have worked hard to establish my career and reputation, and I have enjoyed success. But for me, this is a matter of principle. I am speaking out for those songwriters and recording artists who are struggling to make a living, particularly now, as our industry has been decimated by the pandemic. We need equitable compensation for the rights guaranteed to authors under the Constitution. Given the current ban on large social gatherings and the indefinite pause in live performances, income from licensed digital music services may be the only real source of revenue that music creators can rely on for the foreseeable future. So it is imperative that the devaluation of music, which is a direct result of the DMCA, ceases. And as a result, creators are paid a fair market rate for their music across all platforms. At the dawn of the internet age, DMCA was supposed to provide digital platforms with safe harbor from liability in exchange for cooperation in protecting creators' works. It was meant to provide a proper balance and a symbiotic relationship that benefited all participants and strengthened the legitimate online marketplace. 2 decades later, that balance is decidedly off. In a world where more than 500 hours of video are uploaded to YouTube every minute, more than 1 billion videos are viewed on TikTok every day, and there are over 500 million daily active users on Instagram, it is clear that the massive online services are flourishing, while artists have no ability to combat the rampant infringement that occurs on these platforms. As the U.S. Copyright Office said in its recent report, the balance Congress intended when it established Section 512 safe harbor system is askew. Content owners send hundreds of millions of takedown notices annually, hundreds of millions, and often for each infringing link or file taken down, a dozen more pop up in its place. But even worse, due to the antiquated procedures dictated by the DMCA, internet services with clear oversight and control of content posted on their websites are continuing to monetize and collect advertising revenue on videos containing music, even after that music has been flagged by the music creator as an infringement. How is that a fair bargain? The astronomical number of infringement notices sent by creators is not a sign that the system is working, as some defenders of the DMCA suggest. That analogy would be akin to measuring our country's success in fighting wildfires by measuring the number of attempts to extinguish them. Instead, we need to seek out the root causes of those fires, implement preventive measures, and ensure that they don't reignite. Many of the enormous tech companies who benefit from the safe harbor provisions of the DMCA have the tools to do just that. They have the tools. They have the capability to monitor infringements on their platforms and provide enhanced tools for content owners. They simply choose not to. They are capable of understanding and tracking individual likes and dislikes of the fans who visit the platform with frightening accuracy. And yet we are supposed to believe that putting in place a meaningful barrier to infringement is beyond their capabilities. More accurately, it's beyond their desire. These tech giants are afraid that blocking infringing content will reduce traffic, and reducing traffic decreases their ad revenue. So instead of focusing on platform improvements that drive consumer satisfaction, they rely on copyrighted material, whether licensed or not, to keep consumers engaged. With the DMCA as cover, these companies simply have no incentive to improve technological protection measures. And the courts have facilitated this worldview, broadening application of the safe harbor provision, watering down obligations of online services, and eliminating consequences. The result is an anemic notice and takedown system that still allows big tech to rake in revenue by monetizing access to unlicensed works, despite being notified of the infringements or even repeat infringements. We simply cannot continue like this. I applaud and I thank this subcommittee for shining a light on the damage caused by the unfulfilled promise of a meaningful, effective notice and takedown system. Creators need recourse for the unlicensed, illicit use of their valuable works online, and the DMCA is not providing that to them. Like a classic song or a classic album or band, some creations stand the test of time, resonating across generations. Other products are best left there in the past or updated to reflect a modern world. The DMCA has shown its age. The DMCA is a relic of a MySpace era in a TikTok world. Our nation's countless creators, most of them small businesses, deserve a better system that recognizes the needs of online participants and a procedure that properly applies the rules and implements today's technology with an eye toward tomorrow. Only then can we truly achieve the proper balance and the thriving, legitimate online marketplace this institution envisioned so many years ago. Thank you.
Thank you, Mr. Henley. Mr. Berroya, did I come close to pronouncing your name right? Please correct me.
Yes, Chairman Tillis. The second time was much better. I appreciate it.
Yeah, I knew I butchered it on the opening, so you're welcome. Please present your testimony.
Thank you. Chairman Tillis, Ranking Member Coons, and members of the subcommittee, thank you for giving me the opportunity to testify today. My name is Jonathan Berroya, and I am Internet Association's interim president and CEO. Before I begin my formal remarks, I too feel compelled to personally acknowledge that our nation is yet again struggling to make sense of the unconscionable killing of George Floyd and so many other Black men and women. I'd like to recognize the music industry's leadership in making today Blackout Tuesday. Raising awareness of this issue is critical because until we collectively acknowledge, understand, prioritize, and take meaningful steps to end systemic racism in this country, our history will continue to repeat itself. This is something that we, the people, and you, our elected leaders, must work together to address. Turning to the topic of this afternoon's hearing, IA members are companies of all sizes and represent diverse business models. They themselves are creators, they are distributors, platforms, and licensees of all types of content, and they are committed to working with the rest of the creative community to improve the rights holder and user experience online. I am grateful to have the opportunity to testify before this subcommittee today, not just as a representative of these innovative companies, but also as an attorney who spent much of the last decade protecting hundreds of popular software and video game titles from online infringement, while relying on the DMCA and other effective practices like personal outreach, thoughtful discourse, and good faith collaboration to achieve success. It has been my experience that the DMCA and Section 512 work as Congress intended, despite what the recent Copyright Office report suggests. The digital content ecosystem is thriving thanks to this law. First, the DMCA allows rights holders to quickly take down infringing content without seeking judicial intervention. Second, it gives platforms the legal certainty necessary to host user-generated content and the incentive to collaborate with other rights holders to combat infringement. And third, users can enjoy and create a wealth of legal online content thanks to advances in technology that have been increasingly embraced by the content industry. The 512 report recognized many of the contributions of platforms to the creative community and the need for legal certainty, but incorrectly concluded that Section 512 has been tilted askew. This finding is inconsistent with my experience as an enforcement attorney and as a representative of online service providers. The report failed to take into full account the changing landscape of the creative ecosystem, the positive impact of collaborative measures, and concerns of users, as well as the weight of decades of well-reasoned judicial decisions. The creative ecosystem has evolved dramatically, both in the past 2 decades and in the 4 years since the Copyright Office first began collecting comments for its report. We find ourselves in a golden age of content creation. Tech companies are now creators of and investors in award-winning content, and as consumers continue to demand new ways of accessing content, traditional content companies are investing in digital distribution more than ever before. Second, online service providers have voluntarily created tools that go beyond what DMCA compliance requires to make copyright enforcement more scalable, make legal content easier to find, and make illegal content more difficult to access. They've also adopted technologies to exclude infringing material from their systems and to create new opportunities for rights holders to capture revenue. These actions are not the product of litigation or legislation, but are the result of thoughtful engagement with copyright owners, careful consideration of the rights of consumers, and efforts to guard against fraudulent misuse of copyright enforcement tools. Third, users of online services rely on the flexibility of the DMCA as they both create and enjoy online content. The internet and other digital technologies have ushered us into an era of unprecedented creativity in which the average consumer can create high-quality audio and visual content and share it with the world via the same device they use to order takeout. Hundreds of hours of video are uploaded to IA member platforms every minute. Hundreds of millions of photos and videos are uploaded every hour. Millions of people stream themselves playing video games each month. This explosion in creation is well aligned with the copyright system's constitutional objective to promote the progress of science and the useful arts, as the overwhelming majority of these works are original, non-infringing content. Virtually all of the content uploaded to our members' platforms, every video, photo, and tweet, is a copyrighted work owned by someone. Deciding whether a piece of content is or is not infringing requires knowledge of the underlying protected work, the type of license used to protect it, and in many cases, fair use analysis. The notice and takedown system works because it empowers the people who own the content to make a good faith determination about infringement. It provides clear direction to platforms on how to respond to their takedown requests. And it allows users to protect their rights as creators and consumers by issuing counter notices when their content has been erroneously flagged as infringing. Finally, it is crucial to remember that the overwhelming majority of infringement takes place on websites hosted in foreign jurisdictions outside the reach of US law, not on IA member company platforms. This is a fact that the enforcement community has long understood. Accordingly, the best way to attack this problem may be through the inclusion of DMCA-style requirements in treaties with other nations, rather than amending domestic legislation. Disturbing the balance of the DMCA will do little to curb this piracy, will needlessly reduce legal certainty for all parties involved, and will greatly increase threats to a thriving US digital ecosystem that truly fosters creativity. I appreciate the opportunity to appear today and welcome any questions the subcommittee may have. Thank you.
Thank you. Mr. Preston.
I'd like to thank Chairman Tillis, Ranking Member Coons, and the other members of the IP Subcommittee for inviting me to testify today. My name is Douglas Preston, and I'm the author of 35 books of fiction and nonfiction. I am also president of the Authors Guild, the oldest and largest society of writers in the country, with 10,000 members. from Nobel laureates to first-time authors of all points of view and political persuasions. I just want to say how glad I am that my fellow creator, Don Henley, is with us today. So many authors and creators are struggling to make a living because of the pandemic and will be for some time. We both felt it was important, despite the terrible events of the past few days, to come here today to speak on behalf of creators and the challenges they face earning a living and having their voices heard due to racial discrimination, inequality, as well as rampant piracy. Now I'll move on to my testimony. I'll never forget the sickening feeling I had when I first came across a book piracy website to see all my books, my entire life's work, stolen, stripped of digital protection, and put up on the internet. If any of you have come home to find your house robbed, you know how I felt. That was 12 years ago, and since then, piracy has exploded. Every day, I get email alerts pointing me to half a dozen freshly pirated copies of my ebooks posted online in the last 24 hours. For a while, I went after the pirates, but then I realized, as have thousands of other authors, that it's a hopeless task for reasons I'll explain in a moment. The current situation is enraging and disheartening. It's like being mugged every single day. In the last 10 years, full-time authors in America have experienced a 42% drop in their writing income to $20,300 a year. Much of that decrease is due to rampant piracy. It's hard enough to make a living writing books, but piracy now makes it almost impossible. Today, there are hundreds, if not thousands, of websites devoted to book piracy, such as LibGen, Kisly.net, EPUB.pub, and ebooks.com. Online marketplaces such as eBay and Google Shopping and social media platforms like Facebook openly offer thousands of illegal ebooks for download. Many stolen ebooks of mine, for example, can be found on the Google Shopping main page right now. The reality today is that the internet has become a virtual candy store for the wholesale stealing of the creative work of authors. Now, the DMCA was meant to balance the interests of internet service providers and copyright holders. To achieve this, the legislation provided a safe harbor to ISPs against claims resulting from their users' posting of pirated content if and only if they complied with a half dozen criteria intended to induce cooperation. But that isn't how it's working today. For a series of court decisions, 4 separate criteria were reduced to just 1. ISPs now can benefit from the safe harbor merely by complying with takedown notices, and those takedown notices must state the specific address or URL of each item of infringing content. As a result, an ISP is now only required to take down the specific pirated ebook from the specific URL for which it receives notice. But a typical pirate site has tens of thousands of URLs. In practice, as soon as a pirated ebook or link is taken down, another identical one pops up at a slightly different URL, creating an unending whack-a-mole ordeal for those of us sending takedown notices. Now you can see why I gave up. As soon as I sent a takedown notice, the pirated ebook file popped right back up on the same website, often posted by the same person, and often dozens of more copies would pop up. In 1998, Representative Goodlatte, one of the DMCA sponsors, eloquently stated Congress's intentions with the law. Quote, "If America's creators do not believe that their works will be protected when they put them online, then the internet will lack the creative content it needs to reach its full potential. And if America's service providers are subject to litigation for the acts of third parties at the drop of a hat, they will lack the incentive to provide quick and sufficient access to the internet." Congress's clear intention has not been achieved. The Authors Guild is asking Congress to restore Section 512 to what was intended, which is a notice and takedown, which is a notice and stay down instead of notice law. Congress clearly intended that an ISP take down and then keep down, and if Section 512 cannot be revised accordingly, then the Authors Guild is very much in favor of tossing it out and coming up with a much more modern and efficient and effective way of stopping rampant piracy on the internet. My written statement has examples of our members' frustrating experiences with the current system, and it includes recommended wording on how to adjust Section 512 as the Copyright Office has recommended. The DMCA is 22 years old. It's an antiquated law. It needs to be updated to the 21st century. Thank you.
Thank you. Mr. Hansen.
Chairman Tillis, Ranking Member Coons, and members of the subcommittee. First, I'd like to thank you for your remarks at the beginning regarding what happened to George Floyd and the situation that has affected us all across our country for the last week or so. It's been a sad week, and I'm glad to hear that other parts of the Congress are right now focused on that. For today, I want to thank you for the opportunity given to me to share my thoughts about how the DMCA notice and takedown system works for research libraries and for universities. My testimony is largely about my experience at Duke University, but it's also reflective of many other libraries like ours and like our university across the United States. That includes members of the Association of Research Libraries, the Association of College and Research Libraries, the American Library Association, and the American Association of Law exist to promote the progress of science and the useful arts. Ultimately, our goal is to help our nation and the world better understand each other and the world around us. From the very first Copyright Act in 1790, an act for the encouragement of learning, higher education and libraries were central to the design of copyright law and generators of so many new scientific discoveries and stewards of the records of those ideas. I know there are many stakeholders interested in Section 112, large technology companies, entertainment industry interests. I hope that research and teaching will not be an afterthought for how Section 512 might be adapted, but rather would be a central consideration. Duke, like most other research universities and libraries, straddles both sides of Section 512. We operate as a service provider for a very large network, but we're also significant producers of copyrighted content, and we're rights holders ourselves. From that perspective, Section 512 generally works well for us, and we do not believe that its overall balance is askew, although there are some minor changes that could be made. As a content creator, Duke generates more than 10,000 research articles a year, along with hundreds of books, videos, educational content, and all other types of works. For virtually all of this content, our primary aim is to get people to engage with those ideas. We aim to disseminate those works as widely as we can with, for the most part, no direct financial return, no royalties. We often seek to share research rapidly when it's relevant. For example, recently, a Duke faculty member shared through our systems a paper on a method for decontamination of N95 respirators to address PPE shortages in healthcare settings. It's really important that that kind of research get out quickly. Given our interest in widespread dissemination of ideas, our strong preference is a system that keeps content up online unless there is significant evidence that infringement has occurred. The current notice and takedown system doesn't always do that. For example, for some academic authors who are trying to share their own research with the world, they face barriers because of lack of clarity around rights. In some instances, publishers have made broad assertions under their publishing contracts about their ability to control research. Several years ago, for example, Elsevier, a Dutch-owned publishing conglomerate, reportedly issued 100,000 takedown notices to a site called ResearchGate. ResearchGate is a for-profit site, but most of the content submitted there has been placed there by academic authors who are trying to share their own research with the world. For most academic authors I work with, responding to a takedown notice for their own research is discouraging. It's intimidating, and it's a time-consuming process that they try to avoid. Second, perhaps the most important thing I can say is that fair use is absolutely critical for research and scholarship. Whether you're talking about quotations in literary critique, or copying charts or graphs in a scientific publication, or reusing images in a work that comments or criticizes on art or history, fair use is an everyday part of published research. Courts have consistently found that fair use supports academic scholarship, but other parts of the Copyright Act can make exercising the right of fair use a challenge. Section 512 is one of those. Section 512 doesn't explicitly address how fair use factors into the notice and takedown process. The Ninth Circuit's decision in the Lens case, the dancing baby case, was a welcome development, as it requires rights holders to first consider fair use before making a valid takedown request. However, we know that another factor in this system is the automated content identification, which can limit access to works that are dependent on fair use. We think that automated content ID should be carefully limited. We also know that service providers play an important role in protecting fair use. Some have been proactive by requiring more supporting documentation from those making takedown requests. Unlike the Copyright Office, which in its recent Section 512 study report was critical of those practices, we applaud them and believe service providers should be protected when doing so. So as a service provider, Duke also operates a very large network. We have about 40,000 students, faculty, and staff with network credentials. If our network was its own county in North Carolina, it would be bigger than a third of all other counties in the state. It handles many of the same kinds of traffic that other networks handle: streaming content, email. But our network also serves a special purpose. It's the technological backbone supporting Duke's teaching and learning. It's the research pipeline through which faculty and graduate students obtain materials. It's also an important pathway for health-related information for our university health system. The provisions in Section 512I that require service providers to implement access or implement plans to terminate access for repeat infringers can be problematic. Denying a student access to the network can be debilitating, especially right now where virtually all instruction has moved online. Depriving a student of internet access would be almost equivalent to expulsion. And like many other libraries, we also serve in normal times as an access point for the public to use terminals within our network that connect them out to the internet. We rely heavily on Section 512A for a safe harbor as mere conduits to safeguard against copyright liability for user activity. Students are a special case, but given how dependent we all are on internet access, I would encourage this subcommittee to think hard about whether termination of internet access continues to be an appropriate remedy for instances of alleged infringement. Duke also acts as a service provider in many other ways. We host systems that disseminate scholarship itself. We host information location tools that I'd be pleased to talk more about. I want to end just by saying I realize that some stakeholders feel that Section 512 needs significant change. I hope that this subcommittee will consider the unintended consequences that changes to Section 512 could have on research and teaching, which I believe are core to the constitutional objective of copyright. The incentives and economics of research and teaching are very different from those of, for example, music or film. And it's important that a net that's cast to address legitimate privacy concerns for some copyrighted works not also drag down research and teaching as well. Thank you.
Thank you. We're going to go ahead and move into questions. I'll go first. I know Senator Coons will be back momentarily, but just from a level-setting standpoint, copyright owners today have to worry about types of infringement that couldn't possibly have been anticipated in 1998. Illegal streaming of live sports and the black market for illicit streaming devices sold with libraries of hundreds of films are two examples. In fact, illegal streaming now accounts for 80% of digital piracy. So I guess, and then I guess I could go on to one of the reasons why I just inherently believe that we have to modernize is we are dealing with a different world. I think Mr. Henley said we've got MySpace-era regulations governing TikTok-era technology today. And so, Mr. Berroya, did I finally get it right? I have a question for you. I know that over the years, the tech sector has opposed any changes to Section 512. And why would the tech sector want to continue to be governed by a law that couldn't possibly have anticipated the environment we're in today? We were dealing with modems and dial-up, not ubiquitous broadband. So why wouldn't there be an opportunity to look at aspects of modernization that you would consider to be helpful?
Thanks for the question, Senator Tillis. While your point is well taken, I think it's important to remember that there's been a great deal of innovation on the side of platforms as well as ISPs over the course of the past 2 decades. So the other piece of that is that the DMCA sets a floor, not a ceiling. So it sets the basic standards for what companies need to do if they want to enjoy the benefits of the safe harbor, but it does not limit them from doing more than that. And that's exactly what our member company platforms have done. They've stepped up, they've had conversations on an ongoing basis with many on the creative side of the conversation. As I mentioned in my opening statement, they are creators themselves in many cases, and they're very much aligned with the desires of creators to ensure that infringing materials get taken down off their platforms expeditiously. They do not want to profit from these things, but a legal change, an amendment to the law is not necessary to create incentives for work that is already being done.
But can that be broadly? I understand that some of the larger players anticipating that these kinds of actions could take place in Congress would take steps in the right direction. But the question I have today is, with a completely different technological infrastructure that we're working with, the floor was set appropriately with the DMCA at a time that we understood the capabilities of the internet. Now it's orders of magnitude more available and more powerful and easier to obscure illicit activity. So I guess the question is, why wouldn't we be learning from some of those good faith efforts and potentially creating a higher bar to reduce the amount of rampant piracy that we see? And Mr. Henley, I am kind of curious from your perspective. I know that that was very clear in your opening statement that you think there's a need for changes, but do you want to speak some to why you believe that that's necessary from a technological perspective?
Yes, sir, I'd be happy to. Thank you. The notice unduly burdensome on the artists. Let me just give you a perspective of the magnitude of the problem. There are currently about 6 billion posts on YouTube. And out of those 6 billion posts, 4 billion of them are unclaimed. And out of those 6 billion posts, 84% of them contain music. Now let's say it takes 2 minutes to file a claim. So at 2 minutes per claim, it would take 200 million hours to claim them and take them all down. At minimum wage, it would cost $2 billion. Of course, by then, there would probably be another billion posts on YouTube. So, as has already been said, as you said, this is an endless game of whack-a-mole, and the notice and takedown system is badly broken. Universal Music Group administrates the publishing for the Eagles and for myself, and they have a team of 60 people who sit in a room with computers, and all they do all day long, 5 days a week, sometimes 6 days a week, is deal with the platforms such as YouTube and Facebook. They file claims and they issue takedown notices for the Eagles and for myself. And those amount to between 200 and 500 claims a week. And when a claim is filed, the person who uploads the infringing content can appeal that claim, can dispute that claim. And there's a process where it goes back and forth. You have claim, you have appeal, and then you have a counter notice. And that process can go on and on until finally a stalemate is reached. If the uploader refuses to take down the infringing content, then the artist, the person who created that content, has no choice except to file a lawsuit within 10 days. Now, most artists cannot, they don't have the time or the wherewithal to file lawsuits. So the process is, again, simply overly burdensome on the artists. It's a ridiculous process. It's an outdated process. And Artists shouldn't have to deal with it. Our job is to create music, to create art. Our job is not to police the internet for infringing content. That is the job of the huge platforms. The huge platforms claim that they're simply a conduit through which pass all this content. But they engage with that content. They curate that content. They manage that content. Again, they can identify likes and dislikes, but they can't seem to identify copyrighted material. There's a process that has been instituted, which again is simply not working. The content ID, they call it. Our publishing administrator many years ago contacted Google and asked them if they could please cooperate with us in taking down infringing content. And they said, well, if you will send us your copyright registration numbers, we can flag your content and take it down. Never happened. Then she was eventually, after a year, led to this content ID business. But the content ID is like a big net with huge holes in it. Millions of infringing content falls through the content ID process. It's not effective at all. It's not effective to establish an effective repeat infringer policy. It ignores red flags with respect to patterns of infringement by certain users. YouTube often touts content ID as an unrequired benefit to rights holders. It is not an unrequired benefit to rights holders. It's far from perfect. Again, still allowing millions of unauthorized content to slip through the system. There is no realistic way that rights holders can unilaterally review trillions of web pages necessary to identify infringements and protect their rights. But online services and platforms can. They are the gatekeepers, not us.
Thank you, Mr. Henley. And Mr. Hansen, if I come back for another round, I may ask you to talk about the same subject. And Mr. Henley, I think you were really describing on a broader basis the sheer numbers of people who were experiencing the frustration of feeling like they had been robbed, as Mr. Preston described in his opening comments. Before I go to Ranking Member Coons, I'd like to enter into the record from Dr. Theodore Fetter, President of the Artist Rights Society, which represents more than 122,000 artist members around the world. His letter points out the challenge many small and individual artists face as they attempt to police the internet for infringing content. That objection will be entered into the record. I'd also like to enter into the record a letter from the Copyright Alliance, which represents the copyright interest of more than 13,000 organizations and more than 1.8 million creators. The letter states that piracy is one of the greatest threats to welfare and economic security of individual creators. And finally, without objection, I'd like to enter into the record a letter from the Music Workers Alliance, an organization of independent musicians and DJs, calling on Congress to act on the findings of the recent Section 512 report from the United States Copyright Office. Ranking Member Coons.
And thank you, Chairman Tillis, and thank you to this impressive panel of witnesses. I have a lot of questions, but we don't have a lot of time. So I'm just going to ask of the entire panel that you would answer a sort of a combination of question. Based on your testimony across this whole panel, the current system works well for some and is broken for others. Congress had envisioned rights holders and online providers working together to standardize voluntary technological measures to combat piracy. I'm interested in why that hasn't happened, how you would suggest we combat digital piracy without stifling innovation or free speech, and most importantly, if you could propose one immediate change to improve the notice and takedown framework, what would it be? And I'd welcome hearing from each of the members of the panel in order, starting with Mr. Henley. And if I might say, Mr. Henley, as someone whose creative works inspired an awful lot of the critical moments in my life, I was hearing this song, The End of the Innocence, playing in the back of my mind as we were contemplating today, and I never thought that life in the fast lane would one day involve looking at each other through digital screens. Mr. Henley.
Life is full of surprises.
It is.
I agree with my colleague who is representing authors. There needs to be a notice and stay down regulation, because the notice and takedown process simply does not work. We need to go to a notice and stay down process. You know, the safe harbor in the 512 were never intended to be a get out of jail free card. It was explicitly intended to promote cooperation between the online platforms and the creators and owners of the works they use. So that original arrangement needs to be rebalanced. It will not threaten the internet. In fact, it will enhance the internet by ensuring a viable, legitimate online marketplace for creative works and online services for the benefit of everybody. Let me just tell you what the streaming rates are, just for perspective. Per stream, Apple pays 7/1000 of 1 cent. YouTube pays per stream 35/10,000 of 1 cent. Hard for creators to subsist, to survive with rates like that, especially on top of all the infringement. That's all I have to say at the moment.
Thank you, Mr. Henley. If I might, Mr. Berroya.
Thank you, Senator Coons. From our members' perspective, what's really needed here is additional collaboration. Our members have effectively worked with many large company-directed programs focused on enforcing copyrights online globally. I understand the challenges, and I understand that the challenges are particularly acute for small artists who don't have the ability or currently have an organization that is helping them pool their resources and finding a way to leverage technologies in order to more effectively manage the takedown process and work with some of the websites to the extent that they're based in the US or in a jurisdiction that has similar laws to the US laws, so that those websites can responsibly take down infringing content. But the lack of collaboration and effective collaboration is at the heart of a lot of the current challenges. The law, as it currently stands, incentivizes collaboration and has produced a great deal of collaboration between platforms and content producing companies. And those.
I would respectfully disagree with that.
And I respectfully appreciate your comment, Mr. Henley. And I'm speaking from my own personal experience on this one as well. So I have had conversations personally when I was representing a large trade association that represented the rights and protected the rights of large software companies, where I reached out to a foreign jurisdiction that does not even have US-style DMCA rules. We talked to them about the challenges that we were facing. And even though that jurisdiction's rules did not require them to implement a takedown process, through negotiation and working with them, we were able to assist our members to effectively police their rights on a site, a collection of sites that were causing huge problems for them. So my suggestion here is that we think very carefully, because just shifting the burdens to platforms from rights holders, when we're talking about the scale that, I will acknowledge Mr. Henley is 100% dead on. It's huge, and it's growing every single day, the volume of material that is posted online. The overwhelming majority of it happens to be legal. And the problem is platforms with all their technology cannot decide and produce reliable fair use analysis. They do not know how a particular piece of music is licensed. And there are certainly cases where rights holders are not as careful as perhaps UMG and Mr. Henley's other representatives might be. And they make copyright claims that aren't in good faith and attempt to take down fair use of copyrights. So there's a very delicate balance here in the system. And I think there are a lot of factors that can contribute to making it better. But I think first and foremost, increased dialogue is an important part. There are technological pieces that are at play and that have improved greatly over the last several years. But I think really the old-fashioned dialogue and working with one another to understand these rapidly changing problems is a really, really important first step.
Thank you, Mr. President.
Internet platforms collaborate with only a few of the largest companies in the country, and in a desultory way. They do not cooperate with millions of individual writers or other creators. Many authors I know of the Authors Guild have tried in many ways to engage with these large internet platforms like Google and eBay and so forth. It's an absolutely frustrating experience because these platforms simply are not capable of engaging with small creators and businesses. To answer your second question, really what we're asking for is for notice and stay down, which simply means that once an ISP has been properly and fairly informed, and take away a stolen bracelet. And then the next week, the same bracelet comes in a week later to be sold, you can't just put it up for sale again. So that's all we're asking, that once an ISP has been informed in a proper and legal way that something is stolen property, it stops allowing the sale of it. The other side of this coin is that if the same person in a pawn shop brings in multiple stolen items repeatedly, the pawn shop owner has an obligation to stop dealing with that person. So if a website is hosted by an ISP, or in the example of Google, if it is responding to search requests and sending people to that website, and that website has received thousands and thousands of takedown notices, then the ISP should stop dealing with that website. And I'll give you an example. There's a notorious piracy website called epub.pub that Google was sending people to just freely. Anyone who wanted, type in free ebooks or whatever, Google sends them to this website. This website had received, according to a study by New York University, over 40,000 takedown notices, and still Google was indexing that website right at the top of its search page. It wasn't until the Authors Guild went to Google and said, hey, what's going on here? You've got 40,000 takedown notices. This is a notorious website. And Google then demoted that website lower into its search function. It didn't de-index it, it just demoted it. So look, all we're asking is for ISPs to make a good faith effort to keep that stolen property from being fenced again and again and again on their platforms.
Thank you. Briefly, Mr. Hansen, if you've got something to add to that, because I know Senator Blumenthal has waited quite a while to ask.
Yes, just briefly, I'll comment on our experience as a service provider and the takedown notices that we've received over the years. So just on average, to give you a sense of what we see over this year, we're averaging something like 380 takedown notices a month, which is not a significant number considering the size of people and the volume of traffic that traverses our network. We've seen that number decline pretty dramatically over the years, and a lot of the takedown requests that we used to get used to be based on students uploading popular media to the internet. A major driving factor in reducing that number has been not really copyright innovations, but business model innovations, licensing alternatives, where content has been made available at reasonable prices through reasonable means, where students are able to purchase subscriptions, Netflix, Hulu, Spotify, those sorts of things. And so I think the encouragement of licensing alternatives at reasonable rates and through reasonable means is a major driver that I think would have more of an impact than almost anything where there's a sort of authoritative approach to stop things rather than providing legitimate means through which consumers can obtain access to content.
Thank you. Thank you to the panel, and thank you to Senator Blumenthal for his patience.
Thank you. Thank you to the ranking member, Senator Coons, and to our chairman, Senator Tillis, for having this very, very important hearing. And I will just say right at the outset, this hearing is extraordinarily consequential because it involves a principle, and the principle is accountability. The DMCA and the Community Decency Act, Section 230, accord, in effect, a broad immunity. And both seem to me to be in need of some kind of reform. Now, I strongly oppose the President's executive order on Section 230. I think it is meant to intimidate and suppress free speech. It's illegal. I have supported narrow and targeted reforms to Section 230 that essentially impose accountability for sex trafficking and for other abuses where it has a responsibility, a narrowly imposed legal responsibility that would be imposed by measures to reform it. And so, for example, the Earn It Act is such a measure to stop one of the most sickening abuses in our society, which is child abuse. And it's not a partisan issue. That measure is supported by a bipartisan group of us. And here, it seems to me accountability is also important. Now, I heard a reference earlier to old-fashioned collaboration. It seems to me that old-fashioned collaboration is for an old-fashioned process that no longer really is appropriate to the present technology and the threats to rights that are imperiled by the lack of accountability and enforcement. So I guess my question to the panel is, number one, is there anyone on this panel that thinks the status quo is absolutely okay, no need for improvement, and should be just let alone? And I hear silence, so I would conclude that everybody on this panel thinks that some kind of improvement is warranted.
Excuse me, Senator Blumenthal, this is John Berroya. My apologies, I was having trouble with my mute button. The Internet Association would disagree that domestic law needs to change in order to address a problem that is largely overseas.
So you want to just leave the system as it is?
The DMCA? Yes, Senator. I think the DMCA is working as it was intended to. It preserves the critical balance between all stakeholders involved. The current incentives in the system exist in a way and are handled in a way that is consistent with what Senator Leahy and Senator Hatch presumably had in mind. It functions very effectively. It incentivizes collaboration. And that collaboration, which I refer to as old-fashioned, I meant that in the sense that it's not technological, but the importance of that collaboration is that as technological change on the piracy side of the equation, which happens very, very rapidly, and much more rapidly than any change in law would be able to catch up with, as those things change, collaboration between rights holders and platforms where those rights holders are finding infringing materials allows for a quicker response than might otherwise occur. The DMCA does not prohibit that. It encourages that. And that
Let me just say, because I'm about to run out of time, that argument is absolutely belied by the reports that I've heard from independent artists in Connecticut that are forced to scour YouTube and other platforms searching for infringements. It's not collaborative from their standpoint. It sounds like a full-time effort on their part, and the burden is on them. So rights holders are effectively charged with monitoring the entire internet for infringements on their copyrights, and that burden is especially problematic for independent artists who are more vulnerable to rights infringing activities. So I think that the dismissing of these complaints, and it may not be in your personal experience, but it is in a lot of others, in effect ignores a very pressing problem that we need to address. Thanks, Senator Coons.
Thank you very much, Senator Blumenthal. If I could, I'm just going to ask 2 or 3 more specific questions. I understand the chairman is on his way back, and we will soon introduce the second panel. You don't want me to proceed to introduce the second panel. Okay. If I could, Mr. Berroya, just to follow up, I understand the critical importance of fostering innovation on the internet and the ways in which the dramatic growth of the internet has brought benefits to our country and to our community. But I'm also concerned that in some ways, some of our most profitable companies have found success at the expense of the smallest members of our creative community. In your view, given that there's hundreds of hours of content uploaded every minute, how can smaller artists possibly be expected to police this content, and shouldn't some of our largest and most sophisticated companies shoulder some of the responsibility for the infringing material that's being monetized on their platforms?
Thank you for the question, Senator Coons. Collaboration is essential, and pooling of resources is essential. There were letters that were entered into the record today by a number of organizations. Mr. Preston represents an organization that represents a large number of independent artists and creators and writers. Pooling of resources to deal with the scale of global piracy is the only effective way to deal with the scale of global piracy. Putting the burden on any one of these platforms, and certainly there are large ones with a fair amount of resources, and those platforms have all reached out and will continue to reach out to the creative community and try and identify more effective ways to assist them with this challenge. But the collaboration is essential, both so that platforms understand the challenges that creators are facing, but the pooling of resources on the side of the creators so that they can leverage technology and identify software and techniques, use application protocol interfaces to more quickly identify things and send takedown notices and track responses to takedown notices are all things that can help with the scaling problem. I'm not trying to suggest that the concerns that have been raised by independent artists are in any way, shape, or form overblown. If I were an independent writer or movie producer or musician, I would be facing those same things, and I know people who are facing those challenges. But the reality is, until there is an effort to collaborate more, pool resources, and scale the response to this global challenge, it will continue to be a game of whack-a-mole. And that's not something that anyone on the platform side wants. No one on the platform side wants piracy on their platforms. They don't want profits from piracy on their platforms. They don't need that. They have legitimate businesses, and the overwhelming majority of content on their platforms has been and remains legal content.
Thank you very much. Thank you to the panel. Back to our chairman.
I want to again thank everyone for participating in the first panel. Mr. Henley, all of the witnesses, I think you've given us very important information. I think Mr. Henley mentioned in his opening comment about the dramatic reduction in compensation a creator or an artist is likely to receive in the age of digital piracy. And I think we should recognize the risk that runs of decimating the number of people who are willing to take the time and effort to create something that we all benefit from. That's why I believe that we have to look at reasonable reforms. And I was glad to hear as I went to vote, I'm sorry I had to step out for a minute, that Senator Blumenthal also agrees that we've got a reason to take a look at things and modernize them. I have to believe in a world of technology that we live in today, where many of these same platforms have the technology to virtually anticipate the next song you want to hear or the next thing you want to buy, that there is a way for us to come up with something that's sustainable, not disruptive, and helpful to our creators. And I, for one, hope that we continue to work towards a positive end, and I appreciate all my colleagues who seem to be of the same mind. So I want to thank the first panel for being here today and testifying, and Mr. Henley, thank you for all the memories you've created. And we'll transition to our next panel, which digitally is a little bit easier. I can begin doing the announcements. Abigail Reeves is IP counsel at Engine, a policy advocacy and research organization supporting startups as an engine for economic growth. Ms. Reeves joined Engine from the law firm of Latham & Watkins, where she worked as an associate for 4 years following a clerkship on the U.S. Court of Appeals for the Federal Circuit. Mr. Cary Muzzy is a modern classical music and film composer whose recent works include the original orchestral score for the ballet Casanova and the score for the documentary film Look and See, A Portrait of Wendell Berry, and whose piece Looking Back was used as the recurring love theme in the TV show Glee. Ms. Meredith Rose is a policy counsel at Public Knowledge, which advocates on behalf of the public to promote freedom of expression and open internet and access to affordable communications tools and creative works. Her portfolio focuses on copyright, DMCA, and property reform, among other information policy fields. Mr. Jeff Sedlec is an advertising, editorial, and fine art photographer whose clients include Nike, FedEx, Sony, AT&T. Mr. Sedlec is a professional at the Art Center College of Design in Pasadena, California, and is the president and CEO of the Plus Coalition, a group working to simplify and facilitate the communication and management of image rights. Thank you all for joining today. We'll start with Ms. Reeves' testimony.
Chairman Tillis, Ranking Member Coons, members of the subcommittee. Thank you for inviting me to testify on the value of Section 512 to startups, smaller technology companies, and the users and creators who rely on them. I first want to echo the other witnesses and voices around the country. While Section 512 is fundamental to startups and their experiences are an essential component of Congress's conversation on this topic, we recognize that there are rightly far more pressing issues on people's minds today, and we hope Congress will meaningfully take up the more important conversation about inequality and injustice in this country. And I'm heartened by your remarks on this matter earlier in today's session. Engine is a nonprofit that bridges the gap between policymakers and thousands of startups across the country through research, policy analysis, and advocacy. Rhetoric over Section 512 sets up a false dichotomy of tech stakeholders and copyright stakeholders. Nearly 17 million Americans earned a collective $6.8 billion in 2017 by posting their personal creations on just 9 internet platforms. Technology has democratized creativity, and these and other small platforms have created entirely new ways for independent creators to reach fans and customers, earning far in excess of what those already impressive numbers suggest. Recent events in the US have further highlighted the importance of this internet ecosystem. During the pandemic, and as all of us are gathering and sharing news, working, learning, shopping, and currently testifying from home, we are more reliant than ever on platforms that would not exist but for the DMCA. Overall, Section 512 is working well. In 1998, Congress knew that OSPs would need legal certainty that they would not be automatically liable for when their users were accused of copyright infringement. Today's startups need the same certainty and the protections afforded to their predecessors. Changing the DMCA, even in ways that might seem minor, would shift the ground underneath today's startups. For example, imposing a duty to monitor based on a reasonableness standard would be unworkable and would merely make litigation even more expensive. It can already cost $500,000 just to complete discovery. Indeed, the enormous cost of litigation forced a video sharing startup into bankruptcy, even though the company ultimately won its cases. Because startups would not be able to afford to prove that their practices are reasonable, such a safe harbor would have little value. The subcommittee posed 3 questions for this hearing. First, regarding the notice and takedown framework, it is largely working well, but there is significant abuse of the system and no meaningful opportunities to curtail that. As Professor Tushnet previously explained, most OSPs see very little actual infringement or even claims of infringement. For example, Tumblr, a multimedia blogging site with nearly 500,000 blogs, in the first half of 2019 received fewer than 5,000 DMC takedown notices and removed less than 1,000% of its users' posts in response. Forcing those OSPs to police all the content they host would not catch much, if any, additional infringement, but would come with the substantial drawbacks and expense. Moreover, OSPs lack the information to identify infringement. Rights holders, on the other hand, know what their copyrighted works are and can identify potential infringement, what they want resolved. While Section 512 has been successful, improper takedown notices are a very real problem. In one astonishing example, a musician posted a video of himself playing a public domain song written by Bach, and Sony sent takedown notice claiming ownership of part of Bach's composition, and refused to back down when the musician disputed Sony's obviously incorrect claim. It is well documented that notice senders use Section 512 to hurt competitors or remove content they do not like. Users who receive bad faith notices can dispute them, but they have to wait 10 to 14 days for content to be restored. For an Etsy seller who loses 2 weeks of sales during the holiday season, the effects of those bad faith notices can be devastating. So while notice and takedown does work well, it is subject to substantial abuse. I addressed the second question regarding safe harbor eligibility in my written testimony. Turning to the third question, changing the red flag knowledge standard or imposing an affirmative duty to monitor would be seriously detrimental. It would create new costs and risks that startups operating on thin margins would be unable to bear. Established incumbents already automate many aspects of their infringement monitoring and have the resources to absorb increased legal risk. Startups do not. Filters have inherent limitations. Existing tools have high error rates, but for many types of content, there are no filters, and technology cannot address fact-specific questions of infringement like fair use and licensing. Importantly, these filters are also out of reach for most startups. Developing them costs orders of magnitude more than a startup could afford, and licensing off-the-shelf filters is equally out of range for startups. To sum up, a founder in South Carolina recently told me that changes in how copyright is handled for online content would be one of the biggest liabilities for his company. He aptly explained that a large shift in policy might not have a significant impact on large companies that can accommodate change, but it could unintentionally result in a negative impact on entrepreneurs and the small business community. Thank you again for inviting me to testify today. We know that your review of the DMCA will be an ongoing process and hope that startups and smaller tech companies will continue to have a seat at the table throughout the year.
Thank you, Ms. Reeves. Mr. Muzzy.
My name is Cary Muzzy. I'm a film and modern classical composer. I'm honored to be here, and I want to thank Senators Tillis and Coons for inviting me to speak to the subcommittee about a topic that affects my livelihood and the livelihoods of all professional creatives, the DMCA. I make my living as a composer, and every single day I experience just how broken the DMCA is. Before beginning, though, I want to acknowledge something. I'm not a famous person. People don't know my name. I'm just a working composer. My story and my experiences wouldn't mean as much today if not for the fact that in these hearings, I am allowed to stand shoulder to shoulder with someone like Don Henley. His name lends credibility to us all, and I am so proud that I get to make my statements today alongside of his. The opportunity to possibly make a small difference here is very important to me, and that's why I'm here. So before explaining how broken the DMCA is, let me give you some context for my remarks. I am one of the very few and very lucky independent artists who has access to YouTube's Content ID system, and most of my experience with Notice and Takedown has been on YouTube. Content ID has become a core piece of my licensing business. It's the technology I use to reveal thefts of my music on YouTube. Honestly, this is also why I'm a little bit nervous about speaking out today, because I fear retaliation by YouTube. And to date, it has located a total of approximately 110,000 videos that use my music without permission. Let me be clear, these are not cute little kitten videos. These are commercial uses of my music for car companies and luxury hotel chains, Fortune 500 companies, pharma companies, and dozens of international series that used my music in them as underscore. When I discover these uses, I issue DMCA takedowns against them. And this is where the broken part of the DMCA process revealed itself. After issuing takedowns, I would receive false DMCA counter notifications from these companies through YouTube. In every case, the counter notification said that the uploader's use of my music was a fair use under US copyright law. And in 100% of these counter notifications, that assertion was false. So how did these takedowns usually play out? Shortly after issuing a takedown, I receive an email from YouTube saying that the uploader has filed a counter notification and that pursuant to the DMCA, I have 10 days in which to file a lawsuit against the uploader, or else YouTube will reinstate that video. If I do not file that lawsuit within that 10-day period, the uploader and YouTube can then continue to display and monetize that video that still has my music in it. I have then lost that battle, times 110,000. I'm not a corporation with a staff of lawyers who can file lawsuits for me. I'm just a guy. I am a small business of one person. Copyright law tells me that I have the right of ownership to the music I create. But if I don't have a legal remedy when my work is stolen, do I really have that right? This is the situation that composers like me are in. The DMCA remedy filing lawsuits that isn't really a remedy. There is no remedy for me. I am a tiny David in a sea of tech Goliaths like YouTube and Google and Vimeo and Facebook, and all of them feel insulated from liability because of the way DMCA safe harbors have worked. And because the likelihood that an independent artist like me will be able to sue them is exactly 0%. The mental and emotional toll that it has taken on me, having to spend time every single day for 7 years now, dealing with tens of thousands of individual thefts of my work and trying to resolve them, is extreme. Those are hours I could have spent making music, and I will never know what creativity was lost while policing those thefts. Senators of the IP subcommittee, today I have the most unique opportunity I've had in my lifetime to ask members of my United States Senate to fix a broken law. And that's what I'm asking. I'm asking that you revise the DMCA to help individuals like me who have been left with no rights or remedies. I understand that today's panel includes tech companies and digital services representatives who assure us that the system is working. I challenge them to consider the maddening, routine experience I have described here and to tell me with a straight face that the system is working. I'm just one of hundreds of thousands who go through this every day, artists of all socioeconomic backgrounds, not just the famous ones. If they want to truly partner in the online space, they need to face this reality and dedicate themselves to fixing this problem. Senators, please realize there are many tiny Davids like me who need the government's help protecting their work by holding the Goliaths accountable for the theft that they have so easily enabled, incentivized, and profited from with impunity. We need practical and accessible remedies when our works are infringed. If the world's most tech-savvy companies won't voluntarily help artists like me, then Congress should force them to. I'm here to ask for your help. Please help me. Thank you for letting me tell my story.
Thank you. Ms. Rose.
Chairman Tillis, Ranking Member Coons, members of the committee, thank you for inviting me to testify today, albeit from an appropriate social distance, on this important topic. First, I would like to take a moment to acknowledge protesters currently out in the streets and to say but the smallest fraction of names that must be said. George Floyd, Breonna Taylor, Ahmaud Arbery, Tony McDade, countless others, all of them victims of police violence. This debate that we are having right now cannot happen in a vacuum, divorced from what is going on in America's streets. This is not about content versus tech. I am here to speak about how Section 512 impacts the more than 229 million American adults who use the internet as more than just a delivery mechanism for copyrighted content. They use it to pay bills, to learn, to work, to socialize, to receive healthcare. And yet they are missing from the Copyright Office's Section 512 report. They are missing from the systems and procedures that govern their rights, and too often they are missing from the debate on Capitol Hill. I am thankful to be here representing them today. Reforming the system requires that we acknowledge the ways in which it breaks down. In particular, I will address 3 problems for users' speech: bad DMCA notices, shortcomings in algorithmic enforcement, and the inappropriateness of giving private third parties the power to, without any whiff of due process, remove a family's access to broadband. First, we must acknowledge that bad DMCA takedown notices are real, that they have a variety of causes, and that they happen at an enormous scale. A DMCA takedown erases speech from the internet for up to 2 weeks without any meaningful oversight, even when contested. The extraordinary power of this provision means that it comes with a long and thoroughly documented history of weaponization. One exhaustive study looked at 108 million notices and it concluded that nearly 1/3 of them were problematic and that 4.5 million of them were fundamentally flawed. While the cause of these bad notices ranged from algorithmic defects to outright abuse, the scope of their impact remains staggering. Senders can use takedowns to censor legitimate content. Incomplete or error-filled notices can make it impossible for platforms to identify the works involved. And search and notice bots can and have disrupted live streams and news broadcasts. Some stakeholders, however, still insist on faster takedowns with fewer safeguards and more potential liability for any platform that attempts to filter out defective or malicious notices. Asking for greater power and fewer safeguards is akin to discarding a tank and asking for a nuke. Second, we must understand the private enforcement mechanisms such as algorithmic content identification that have grown up atop Section 512. These private solutions sound good in theory, but the reality of their implementation is messy and full of difficult design choices. Because they operate automatically, these algorithms can instantaneously remove speech that may otherwise be political, educational, or newsworthy. Policymakers must grapple with what users and artists alike have understood for ages, that the balance of equities in practice is determined less by the contours of law than by the aggregate result of technological limitations, financial incentives, and design choices with no clear right or wrong answers. Finally, I want to address the elephant in the room, and that is broadband access. We should not permit, let alone strengthen, provisions of law which allow third-party private actors to terminate a person's internet access unilaterally and without even a whiff of due process. There are several bills currently before Congress to expand broadband access, yet some stakeholders insist that they need more power, not less, to force an ISP to disconnect its customers based on pure accusations of copyright infringement. When the DMCA was passed in 1998, ISPs were software providers that operated over the telephone network. Being dropped by your ISP meant uninstalling America Online, living in homes serviced by only one broadband provider. Being disconnected means losing access to the internet in its entirety. The punishment is now wildly disproportionate to the accused, not even adjudicated, offense. With economic and social upheaval, Americans are in the streets, in their homes, and all of the time they are online. They are debating and across ideological and geographic divides. The internet is how we bear witness. It is how we see, with the hope of understanding, those whose experiences, whose struggles are not our own. It is how many Americans were first exposed to the tangible reality of police brutality and systematic oppression. It is how the work of community activists and organizers is amplified and how injustice is brought before the eyes of the world. If we are to strike any sort of new balance, it must keep the needs of 229 million voices and their ability to speak in front of mind. Thank you.
The opportunity to testify today on Section 512. My name is Jeffrey Sedlec. I've been a professional photographer for 35 years and am the author and owner of hundreds of thousands of copyrighted photographs. I make a living creating and licensing photographs to appear in all manner of media. The photographs that I create and license are protected under U.S. copyright law, at least in theory. In reality, my photographs receive very little for 512, ignoring illegal activity, allowing infringers to infringe, exploit, and monetize my work with impunity, unless and until I submit a DMCA takedown notice. As a result, I'm forced to dedicate my days and nights to searching for infringements, making screenshots to document infringing material, collecting hundreds of thousands of infringement URLs, through obscure website menus that are different on every site to find DMCA agent information, drafting and submitting takedown notices, and responding to inane, unnecessary delay tactics such as follow-up questions from service providers. Once the infringement is taken down, it will inevitably return, often on the same day. Providers uniformly fail to effectively implement and enforce repeat infringer policies. Enforcing rights under the DMCA is an impossible task, not just for me, but for my fellow creators across this nation. Most visual artists operate as micro businesses, often with no employees. Like other creators, in order to feed my family, I must generate revenue by creating and licensing new works. But in attempting to license my works, I find that I'm forced to compete with hundreds of thousands of unlicensed, unpaid, infringing uses of my works on service providers, essentially competing with my own works. If I don't enforce my copyrights, my work has no value and my business is not sustainable. But if I dedicate the time and effort required to identify and repeatedly enforce my copyrights with takedown notices, I have no time left to create new works. This is an untenable situation, one that I and innumerable other visual artists and other small businesses are forced to confront on a daily basis. Certainly, this is not the effective, balanced system envisioned by Congress when it enacted the DMCA. The fact that millions of takedown notices is not a sign of success. It is a sign of an unbalanced system under strain and on the verge of failure, if not beyond. Ranking Member Coons today requested specific suggestions. I respectfully suggest the following revisions to 512 to achieve a balanced and effective system. First, revise and clarify the knowledge requirements, recognizing the service provider's right and ability to control infringing activity and deeming that willful blindness and negligent blindness are the equivalent of actual knowledge. Encourage service providers to collaborate with creators and other stakeholder groups to implement non-proprietary opt-out and opt-in registries available for voluntary use by creators and rights holders. Third, for visual works, image recognition technology is readily available, scalable, highly accurate, and perfectly suited for the task. In addition, service providers should be required to search embedded metadata to identify infringing works. Require that upon receipt of a representative list of links to infringing material, service providers must employ available technologies to identify examples, but all other existing infringements of a copyrighted work. Require that service providers implement a notice and stay down procedure, replacing the ineffective notice and takedown requirement. Define repeat infringer as a user who receives 2 or more takedown notices. Require that service providers implement and strictly enforce a repeat infringer policy. Recognize embedded metadata and digital watermarks as standard technical measures. Require that service providers maintain and preserve all metadata and digital watermarks in all files uploaded to their platforms as a condition of eligibility. Grant the Register of Copyrights the authority to establish and maintain a list of additional standard technical measures. Either waive the advanced registration requirement for filing infringement claims in response to a 512 counter notice, or toll the counter notice period during the pendency of the stand shaming creators and threatening their privacy and security. Clarify that infringement by reason of the storage excludes the distinct exclusive rights to display, distribute, perform, and create. Require as a condition of eligibility that service providers must disclose the identity of infringers so as to provide rights holders with an affordable and discover that against their databases of uploaded works to identify any infringing works. In addition, I agree with and recommend the solutions proposed in the Section 512 report issued by the Copyright Office. I make these suggestions on behalf of American Photographic Artists, American Society for Collective Rights Licensing, American Society for Media Photographers, Digital Media Licensing Association, the Graphic Artists Guild, National Press Photographers Association, North American Nature Photographers Association, Plus Coalition, and the Professional Photographers of America. In closing, I again thank the subcommittee members for your efforts to improve the Copyright Act and for the opportunity to share my experience and suggestions in my testimony today. Thank you.
Thank you, Mr. Sedlec, and thanks to all the witnesses for working with us remotely. I think your testimony was very helpful, all of you. Ms. Reeves, Mr. Muzzy, and Mr. Sedlec, this question I'd like for y'all to respond to. Ms. Reeves, when you were talking, you were discussing how we could create barriers to entry that could cause either businesses already in place to go out of business or others just not decide to go down this path because of the lack of certainty. I do believe uncertainty was what drove the original DMCA, and it gave rise to a lot of success stories. But I started at a high-tech startup, or I was at a high-tech startup company in the mid-'80s, and it was more in the realm of businesses that you were speaking to. But I'm also trying to find a way to balance that against the startup community of creators. I was thinking when Mr. Sedlec and Mr. Muzzy were speaking that we could have a whole generation of creators that could take a look at the threat of their life's work. You see the argument that we have an economic ecosystem on either side of this argument whose concerns are not quite being addressed if you're in the creator community, and that just resisting any change seems to only benefit a segment that's done relatively well at the expense of an entire population. That every day my office gets reports of those that we heard from Mr. Preston, Mr. Muzzy.
To their craft and to find ways to reach their audience and to monetize that. And all of that wouldn't have been possible because these platforms couldn't have existed but for the DMC.
Mr. Muzzy and Mr. Sedlec, if let's say you were a few years younger and you were weighing your options on ways that you were going to provide for yourself and your family, and if you knew then what you know now about the daily challenges, how would that have affected you on career choices you would have made back then?
Senator, I will admit that I've said a few times recently I should have just gone to med school. But I want to be clear about my position that I was 39 when I was finally able to leave the business side of the music business, working in rights clearance and business affairs and these kind of things, to make a living at being a full-time composer. And when you write underscore and instrumental music, that's a pretty niche thing. It's not like being a pop star. By the same token, it's that kind of music that finds its unlicensed uses in videos, and you get commercials used, you get commercial entities using your music without permission, and then saying, you should be lucky that we picked yours. I would have preferred a license. I've wanted to be a composer since I was 7 years old and saw Star Wars in the theater, and my mom told me that writing the music for the movie is a job that someone has. So I'm much older than 7 now, and I'm an optimist. I'll confess that while I do think occasionally about going to med school, I'm in this game for the long haul. I'm a composer, I love what I do, and I'm one of the fortunate few that gets to make a living at it. So I try not to complain too much.
Before I turn to Senator Coons, Mr. Sedlec, do you have anything to add?
I do. If I was a teen looking at what I was going to be doing, I would select being a photographer, but perhaps not a professional photographer. I might have gone to law school and then run for the Senate and be sitting next to you, attempting to fix the mistakes in 512. I am a teacher at the Art Center College of Design, and I have been for 25 years. And these are some of the most talented young artists I have ever seen or met. And they have slim to none chance at success in the professional world because out of the gate, all of their works, as soon as they post them online, will be taken, will be used in competition with their efforts to earn a living. And there's little to anything they can do about that at this point until 512 is revised.
Well, don't share that in any of your classroom conversation yet. Hopefully we can come up with some fixes to give them some hope. Senator Coons.
Thank you, Chairman Tillis. Mr. Sedlec, that was a fairly forceful conclusion. As someone who imagined myself once capable of creativity, but instead did go to law school and did end up as a senator, I will take your point to heart. If I might briefly, because this has been a 2.5-hour hearing at this point, Ms. Reeves, just be a little more specific about the challenges with policing copyright infringement for a startup company. And do you believe that industry standardization would actually alleviate that burden?
Thank you for the question, Senator Coons. So to reiterate, for so many of the companies that we work with and small platforms across the country, they just don't see that much infringement. And so any mandatory imposition of here's what you have to do and here's how you want to do it is going to impose a burden on those companies. And because there's just not that much infringement on the platform, it's a burden that won't catch much additional infringement. And to your second question in terms of standardization, I go into more detail and attached a full paper to my written remarks about the limitations of filtering technology. Because while there have been efforts to automate and use algorithms to detect and try to detect potential infringement by a lot of rights holders and by technology companies, those are imperfect. They have high false positive rates, but very importantly, a lot of tools just do not exist. For example, for images printed on physical products, for a platform that hosts multimedia work, there would be a need to be able to filter and screen for all different types of content. Many of those tools just don't exist and would have to be created, especially as startups are coming up with new ideas. We would have to create tools to screen for whatever the next idea is.
Thank you. Ms. Rose, I've heard complaints about abusive takedown notices and counter notices, but litigation is a very costly and time-consuming way to resolve these disputes. Should we be exploring an alternative dispute resolution process for those sorts of situations?
Thank you for the question. I believe that That is an entirely fair avenue. I think the question would be around the sort of inevitable design choices of what that venue would look like. Our concern with the Copyright Office's Section 512 study is that they tied that to a particular piece of legislation, which is much broader and more complex than simply resolving DMCA notices and counter notices. So it depends entirely on the execution, but I think in theory, there's a lot of merit to the idea.
Thank you. Thank you to the panel. Thank you to the chairman. I appreciate your persistent, enthusiastic engagement in exploring DMCA and look forward to finding a way to move forward together.
Thank you, Senator Coons, and thank you so much for being a part of what I believe is one of the more extensive efforts for any legislation that's moved through this Congress to get voices on both sides heard. Thanks again to all the witnesses who participated today in the hearing, and especially for Senator Blumenthal and Ranking Member Coons, who was able to come here in person. I thought it was an enlightening discussion, and it's given me a lot to think about, and I know my staff have been taking copious notes. We reserve the right to reach out to you all and talk to you. Ms. Rose, I specifically would like to follow up with you on your opinion of the CASE Act and whether or not that could serve as a basis for anything going forward. I think that we've heard today, though, I really do believe it reinforces what I said at the beginning of the hearing. As we redesign the notice and takedown system, we have to do so in a way that acknowledges the realities of the scale that we've experienced today, which are orders of magnitude beyond what the DMCA could have possibly anticipated. We have to find a path forward that allows copyright owners to flag pirated content, have it quickly taken down, and for that material to stay down where it's clearly in violation. But we also have to make sure any new notice and stay down system doesn't unduly burden businesses or individual consumers, because we want the innovation and the creativity that comes from that. I'm not sure what it looks like at the moment, but that's something I'm going to be working on with my colleague and ranking member, Senator Coons, and our staff will keep moving forward to our December DMCA reform discussion draft. Thank you all for participating in the hearing. Please stay healthy, and please pray for those who are going through difficult times these days. This hearing is adjourned.